Hello everyone and welcome back to your channel Lawpedia. This is me Jasmine, sincerely hoping and praying all of you are doing a little better now. The situation has improved. Hopefully with vaccination and other drastic efforts, we will overcome this difficult time as well. So in today's small video, we'll be discussing something about hate speech. Very interesting fact that why are we suddenly discussing hate speech in today's video? That's because it's a news as a panel constituted by the Union Home Ministry will very soon suggest reforms to the British era Indian Penal Code, and these reforms are likely to propose a separate section on offences related to speech and expression. So now this is a very important reform if it happens very soon, that there would be a separate section actually defining what hate speech is and what will be the specific punishment for the same. And why will it be important? Because currently there is no clear definition of what constitutes a hate speech in the Indian Penal Code. So moving a little bit backward and understanding the background of it, earlier in 2018, the Union Home Ministry had written to the Law Commission to prepare a distinct law for online hate speech, acting on a report by a committee headed by former Lok Sabha Secretary General T.K. Vishwanathan, who recommended stricter laws. So now this particular committee was formed after Section 66A of the Information Technology Act that provided for punishment for sending offensive messages through online communication services was scrapped by the Supreme Court of India in 2015. So now the first thing that you need to see over here is, or you will ask over here is, what is hate speech? So now hate speech as such, as I have already stated, has not been defined anywhere in the acts by the Indian government. However, in a more general sense, hate speech is an expression which is likely to cause distress or offend the other individuals on the basis of their association with a particular group or incite hostility towards them. Hate speech even has the potential of provoking individuals or society to commit acts of terrorism, genocides, or ethnic cleansing. So basically anything that attacks the particular group of persons or any act of a particular individual, verbal, whether in speech, writing, or any other behavior that specifically attacks a group of people because of their identity, because of their association to a particular religion, because of who they are actually, and all this leading to the incitement of violence and disturbance of public order would come under the ambit of hate speech. Till now, we have understood that there is no single definition of hate speech provided according to any Indian Act. However, this does not mean that we do not have any legislations that deal with hate speech. Indirectly or directly, we have legislations across the various Indian acts that deal with the ambit of hate speech, and the Honorable Supreme Court has also upheld that freedom of speech and expression cannot be given so much liberty that the public order, peace, tranquility is disturbed. People have to understand and learn that the right given by the form of free speech and expression is also subject to limitations thereby provided in the constitution itself. However, if we observe whatever is happening around us, we would see that the provision of hate speech or the sections provided in the Indian Penal Code for hate speech have been drastically misused very recently by the various factions of the government in order to prohibit free speech and expression. Let's move forward and understand the legislations that deal with hate speech. So now these are the broad sections which you will read, and you may be confused that okay, whether it's a hate speech or not. I'm listing down all the Indian Penal Code sections hereby which may deal with hate speech aspect. Section 124A, which penalizes sedition. So now the subtle difference over here would be that the offense of hate speech affects the state indirectly by disturbing public tranquility, while sedition as an offense is an offense directly against the state. And to qualify as an offense under section 124A of the Indian Penal Code, the expression must threaten the sovereignty and integrity of India and security of the state. So that's the subtle difference between both. The next section that you can refer is section 153A of the Indian Penal Code, that penalizes promotion of enmity between different groups on the grounds of religion, race, place of birth, residence, language, etc., and doing such acts which are prejudicial to the maintenance of harmony. We have already covered this particular section in our previous videos. Would be putting that also in the description box for you to understand. So next section is section 153B of the Indian Penal Code, which penalizes imputation, assertions prejudicial to the national integration. After that, section 295A of the Indian Penal Code, which penalizes deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs. So now section 298 IPC. So next is section 298 of IPC, which penalizes uttering words with the deliberate intent to wound the religious feelings of any person. And lastly, you can see is section 505, which penalizes publication or circulation of any statement, rumor or report causing public mischief and enmity, hatred or ill will between classes. If you'll understand the Indian Penal Code, the following sections would deal with some or the other aspects of hate speech. Let's move forward. In our next legislation, that is Representation of People's Act, section 8, section 123 clause 3A and section 125. So now section 8 of the act basically disqualifies a person from contesting election if he is convicted for indulging in any acts amounting to illegitimate use of freedom of speech and expression. So if you'll read the overall section, the gist or the theme that you can observe is that if you use your right, if you use your freedom of speech and expression in an illegitimate manner, so you will be disqualified from contesting election under the Representation of People Act 1951. Next is section 123 clause 3A and section 125. So now these sections prohibit promotion of enmity on grounds of religion, race, caste, community or language in connection with election as a corrupt electoral practice and prohibit it. Now we come to the Model Code of Conduct. Interestingly, the Model Code of Conduct also provide certain guidelines or certain measures that have been given in order to curb hate speech. So in contrast to your Representation of People Act, the Model Code of Conduct provisions are for guidance of both the candidates as well as the political parties. MCC, as we all are aware about, it's a set of guidelines which have been evolved with the consensus of political parties and issued by the Election Commission of India. Now, if you read these guidelines, the item 1 of the Model Code of Conduct, that is the general conduct, prohibits parties and candidates from making any appeals to caste or communal feelings for securing votes. Further, no party or candidate can indulge in any activity that may aggravate existing differences or create mutual hatred or cause tension among different castes, communities, religions, or linguistic groups. Of course, now you will say Indian elections thrive on these particular factors. However, indirectly they may be doing it. Directly, the Model Code of Conduct strictly prohibits these practices. Moving forward, we'll be understanding under the section 7 of the Protection of Civil Rights Act 1955. Incitement to and encouragement of untouchability through words either spoken or written or by signs or by any visible representation or otherwise is punishable. So if you use certain words which encourages untouchability, which incites such values or behavior, that particular speech or verbal expression would be penalized under Section 7 of the Protection of Civil Rights Act 1955. Now, concluding the legislation aspect, not going too far, with the Code of Criminal Procedure 1973, broadly the sections of the CRPC which deal with hate speech are Section 95, empowering the state government to forfeit publications that are punishable under Section 124A, 153A, 153B, 292, 293 or 295A of the Indian Penal Code. Section 107 empowers the executive magistrate to prevent a person from committing a breach of peace or disturbing the public tranquility, or to do any wrongful act that may probably cause breach of the peace or disturb public tranquility. Very, very simple language, clearly stating that this section may be used to curb hate speech. Now, Section 144, this particular section empowers the district magistrate, a subdivisional magistrate, or any other executive magistrate by the state government in this behalf to issue order in urgent cases of nuisance or apprehended danger. Now, it's important to understand that the above offences are cognizable and thus they have serious repercussions on the liberties of citizens and empower a police officer to arrest without orders from the magistrate and without a warrant, as in Section 155 of the CRPC. Now we come to a very, very important part of our video, that is case laws. So understanding any topic without understanding the case law would be meaningless. So we'll always cover our explanation portion after understanding the hate speech, after understanding why we are talking about, after understanding various sections of the Indian acts that may deal with hate speech, we come down to case laws. Now, in a very important judgment of Shreya Singhal versus Union of India, which struck down Section 66A of the Information Technology Act, the Supreme Court of India had differentiated between three forms of speech, namely discussion, advocacy, and incitement, and it was held by the court that a speech can only be limited on the grounds of exceptions mentioned in Article 19(2) when it reaches the threshold of incitement. All other forms of speech, even if offensive or unpopular, have to be protected under Article 19, Clause 1, Subclause A. So, incitement is the key to determining the constitutionality of restriction on free speech. Now, next very important case that you must all have read, which is a very recent case, which is Amish Devgan versus Union of India. In this particular case, not covering the facts, so certain aspects I've highlighted in this slide as well as in the next slide in order for you to better understand how does the Supreme Court of India balance between both the scenarios. Court stated that a citizen or even any influential person is under no obligation to avoid a controversial or sensitive topic. Even expressing an extreme opinion in a given case does not amount to hate speech. This is a very important interpretation, and court also stated only aggravated form of insult to religion when it is perpetuated with deliberate intention and malicious intent to outrage the religious feelings of that group, then only it will be punishable. So now what kind of extent is the criticism is being made, how much of incitement is used, what are the various circumstances surrounding a particular case would be looked upon by the Honorable Court before pronouncing it as hate speech. Further, the court also stated that a speech by a person of influence, such as top government or executive functionary, opposition leaders, political or social leader of following, or a credible anchor on television show, carries a far more credibility and impact than any statement made by a common person. So this is a very common point of understanding, that if a TV anchor or if any important political personality or any top government functionary makes a statement, it would definitely derive more credibility than statement made by us individuals, because we are normal common people. So In such scenario, the evaluation by the Honorable Court would be according to the circumstances. That means significant consideration would be given that the person was a person of influence. Now, freedom and right cannot extend to create public disorder or armor those who challenge the integrity and unity of the country or promote or incite violence. This particular sentence are very important, in which Supreme Court has clearly stated that freedom and the right, like freedom of speech and expression provided under the Constitution of India, cannot go to the extent of creating public disorder. Lastly, so while we are a multicultural society, we are committed to the idea of equality. Such statements being made, such a form of expressions being used which make certain groups or certain faction of people lose their dignity, their self-worth, contributes to the creation of disharmony among the groups, and this would definitely erode tolerance and open-mindedness. This is what Supreme Court has actually stated in the judgment of Amish Devgan versus Union of India. So with this, we come to the end of our today's video. I hope you did understand some of the aspects of hate speech. You understood what is hate speech. You understood that there is no particular law defining hate speech. You understood the case law, certain legislations dealing with the aspect of hate speech as well. I hope the video was useful. Please let me know in the comment section down below if you have any doubt. And until the next video, as we always say, stay home, stay safe, and keep learning.